Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
This court hearing gets intense as a sovereign citizen tries to test the judge's patience. And spoiler alert, it doesn't end well for him. If you're not familiar, sovereign citizens believe they can simply opt out of laws, claiming they're above them somehow. The back and forth in this one is wild, chaotic, and honestly kind of hilarious. Grab some popcorn because you're in for a ride. Let me know what you think about this hearing in the comments. And if you enjoy this kind of content, make sure to like and subscribe. Let's jump in.
Hello, Tariq Samar Tarikade here.
Already, Judge. Courtroom Feaster Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No.
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
see you at 3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Spoiler alert. This genius shows up at 3 o'clock, even though he told the court he'd be there at 3:30. Classic move. This right here proves he knows the judge has jurisdiction, no matter how much sovereign citizen nonsense he tries to spin. Now the judge is about to lay into him for lying to the court, which, in case you didn't know, is a massive no-no. It's called contempt, and yeah, it can land you in serious legal trouble. This guy isn't just wasting the court's time. He's about to find out the hard way that you don't play games in a courtroom. What do you think of his strategy? Personally, lying to a judge seems like a bold and incredibly dumb move. But hey, to each their own. Hashtag.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right. You understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a Fleeting and eluding,
fleeing and eluding, third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
I really need someone to explain what this guy was thinking. First, he lies to the judge about when he'd show up. Then he strolls into court with no mask, boldly claims the court has no jurisdiction, and demands the case be dismissed because there's no injured party. Like, how many crayons did he eat before coming in? Let's break it down. If you're standing in a courtroom, that's a pretty big clue the court does have jurisdiction. And a no injured party argument? Totally irrelevant here. You don't need a physically injured victim to prosecute charges like fleeing and eluding. This guy's acting like he's in a kindergarten debate club, and spoiler, it's not going well. Let's jump back in and watch the chaos unfold.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them all tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
I'm entering a plea of demurrer.
Okay, you've already done that.
Is anybody else starting to feel a little bad for this guy? I mean, Judge Simpson is absolutely cooking him alive. You can tell the judge has zero patience left for these sovereign citizen antics. He's just done. This guy walks in acting like it's some kind of chill preliminary hearing. But let's be real, he's completely out of his depth. He has no idea what he's talking about. And it's honestly painful to watch. He's demanding evidence at a hearing where that's not even required. Like, what? Why not just get a lawyer? They literally offer free legal aid. But nope, he's out here trying to argue with the court like he's going for Olympic gold in courtroom nonsense. What do you think of the strategy? Because personally, I think it's a disaster. Let's get back to it.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not.
Don't need to.
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
Do you guys think this guy is pretending to be clueless? Or is he actually this lost? Because he's out here asking for a jurisdiction hearing like that's going to magically undo everything. In case you didn't know, a jurisdiction hearing is when you challenge whether the court even has the authority to hear your case. And guess what? That kind of thing happens at the very beginning, not halfway through a case, after you've already shown up in court at 3:00 p.m. This guy seriously acts like he just heard the term on Reddit and decided to run with it. Newsflash. If you're in the courtroom, your case is scheduled, and you're being addressed by a judge, yeah, the court has jurisdiction. He's out here trying to wave it all away like he's casting a spell. Who's giving him legal advice? A magic 8-ball. Let me know what you guys think in the comments, and let's dive back in.
The court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that,
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
in person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
So
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
just for the record, I'll put it on the record that I object. But under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Is there anything else?
Well, I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
So you may leave.
Oh, is it being mailed? I'm trying to figure out how to get the paper.
You can check out at the front counter.
Okay, then.
I know this guy's a sovereign citizen and clearly not working with a full deck, but do you think Judge Simpson was too harsh on him? Personally, I don't think so at all. Yeah, the judge was definitely firm, maybe even a little rude, but honestly, it was exactly what this guy needed. He came in trying to play games, and the judge hit him with a much-needed dose of reality. Maybe now he'll actually come prepared next time, and maybe even get a lawyer, because let's be real, this whole sovereign citizen trend is getting out of control. These people latch onto conspiracy theories and fake legal loopholes, thinking they found a magic exit from consequences. It all boils down to one thing: avoiding responsibility. And thanks to the internet, more of them are popping up, feeding off misinformation and convincing each other they're untouchable. But this isn't a game. This is real life. You can't just walk into a courtroom and expect to rewrite the rules. Judges like Simpson are doing what needs to be done, standing firm, not entertaining the nonsense, and reminding these people that the law still applies. Honestly, maybe if more judges handled it like this, we'd see fewer sovereign citizens wasting court time and taxpayer money. What did you think of the hearing? Was Judge Simpson too harsh, or just right? Drop your thoughts in the comments. I love reading what you all have to say. And if you enjoy this kind of content, make sure to like and subscribe. Thanks for watching and take care.